Welcome to our fourth part of the Conflicts and Labor Unions chapter in our Human Relations course. Here we are about to describe the process of collective bargaining. We should understand the types of bargaining issues and the rights of management, and discuss some strategies when working with unions. So with that, let's jump into collective bargaining. So, when employees of an organization have voted to unionize, to establish a labor union for that organization, the process for bargaining, for collective bargaining, will start. So, collective bargaining is the process of negotiating an agreement that is between management and the employees. So, the goal here is for the organization, for management, and the union to reach a contract agreement. And this contract agreement will be put in place for a specified period of time. And when this time has lapsed, there will be a new contract negotiated. And these negotiations can take months, if not years. So they take a long time. And you have representatives of the labor union and you have representatives of the organization that actually engage in the negotiation, that talk to each other to figure out a contract agreement. So there are three main classifications of bargaining topics. There is A, mandatory, 2 or B, permissive, and C, illegal. So number A, or letter A, is the mandatory category. And this category includes the things that we typically negotiate around when it comes to collective bargaining. Things such as wages, health and safety, rights of management, working conditions, and benefits for the employee. They all are in the mandatory category. Permissible topics are the ones that include things such as drug testing, equipment needed. These are things that still matter for the organization but are not required. They're not mandatory. Having these permissive topics on the table and management refusing to discuss them or refusing to negotiate them may hurt morale. So even though they're not mandatory, it might be in the organization's best interest to negotiate on those. Illegal topics would be something like discrimination of a certain group in the organization for any type of employment decision. And that is illegal and should never be covered. Nor should it occur, obviously. On the left side of this slide, you see some examples, additional examples of bargaining topics. And we talked about some of them already. Things such as pay and benefits, even things such as how do we classify jobs and how do we evaluate people. Those things might be covered by the Memorandum of Understanding, the MOU, between the organization and the labor union. On the right side, your textbook talks about the different steps that occur in the collective bargaining process. And there's five steps. The first step is preparation. That really means we are finding out what we need to be doing. We are preparing for the negotiation. We are picking the people who will make up our negotiation team. We try to anticipate what the union might demand. So each organization, the company or the labor union, will prepare. They will think about what are the things they want in that contract negotiation, who will do negotiations, what will the timeline look like, etc. Then we come together to set those ground rules, to set the timelines, so to say, the process for the negotiation itself. Then once the negotiation starts, the collective bargaining starts, each party, each organization will present their proposal, and this will sort of go back and forth for a little bit. So each party will present a proposal, there will be conversations and discussions, there will be revisions to those proposals, and then new meetings. So there is an iterative process between presenting proposals, discussing them, and revising them. And once all of the details have been settled and the parties have come to an agreement, then the contract will be written and it will be voted on by union membership. And hopefully at that point, the contract is in effect. And as you can see from this process, there is no wonder that these collective bargaining negotiations take months or even a year or two sometimes, given how intensive they are and the amount of work that goes into this kind of a negotiation. So, what happens if we have a bargaining impasse? Well, if the two organizations are not able to come to consensus or to come to agreement for the contract on the collective bargaining agreement, we call that a bargaining impasse. And an impasse here means there is an inability to agree on a contract. There are various different strikes that can happen when the labor union and its member is showing its displeasure regarding this bargaining impasse. We can have what's called an economic strike, which is when the labor union and its members are unhappy about the economic conditions. So they are just not satisfied with economic conditions during the contract negotiations. We might also have something called an unfair labor practices strike. And the goal of this one is to get the organization, the company, to stop committing to what the union believes is unfair labor practices. And the unfair labor practices strike does not need to happen during negotiations, where you typically see or where you see the economic strike happening during a negotiation. So impasse might then lead to a strike. So this bargaining impasse could mean that we're going to a strike or something else like a lockout. So a lockout happens when the organization does not allow the worker to go to work. And the goal for that is to put pressure on the union to actually accept the contract. So a lockout can only be legally conducted when the existing collective bargaining agreement has expired. So the organization, the company, is essentially locking the workers from coming to work. And there is genuinely an impasse in contract negotiations. So we're not able to come to an agreement in the contract negotiations. Then a lockout could happen. We also might have a strike, and the goal of a strike is for the workers to protest. And so they choose to not go to work because of that contract disagreement or that bargaining impasse. And here again, the organization here, the labor union, is trying to put pressure on the organization to accept the proposed contract. We might also have things such as slowdown or a sick out or a walkout, maybe a little bit milder versions of the lockout or the strike. So the slowdown is an alternative to a strike where workers are intentionally just less productive at work. They do things, but they do them more slowly. A sick out is when members of the union call in sick, and a walkout is an unannounced refusal to perform work. And this might be illegal because it's not sanctioned by the labor union and it's not part of the process. Sympathy strikes is when work is being stopped by other unions because they are showing support for the union that has a bargaining impasse in place. So for your exercises, go ahead and research some negotiation techniques, then maybe list and describe the different options. Which one do you think would work the best when you negotiate with unions? Of the list of the bargaining issues that we saw in this section, which do you think would be the most important for yourself, and why is that? So a couple of things to contemplate on. So in summary, collective bargaining is the process of negotiation, the contract with union representatives. Collective bargaining, to be legal, must always be done in good faith. There are three categories of collective bargaining issues. They are mandatory, permissive, and illegal. The collective bargaining process can take a lot of time. Both parties prepare for the process by gathering information and reviewing old contracts. They then set timelines for the bargaining and reveal their wants and negotiate on those wants. A bargaining impasse occurs when members cannot come to an agreement. When we have a bargaining impasse, a strike or lockout of workers can occur. An economic strike occurs during negotiations, while an unfair labor practices strike can occur anytime and as well during negotiations. A sick out can also be used when workers call in sick for the day, and these strategies can be used to encourage the other side to agree to collective bargaining terms of the contract. So with that, we are finishing this part, and I'll see you back for the next part where we will be discussing